recording. That's our only thing. Lena, are you recording?
Yes.
All right. Good morning, folks. I'm welcome to our virtual oral argument here this morning. We are recording this. It is not being live streamed, but it is loaded later in the day. So please give your name and the name of your client when you begin to speak. According to the current protocol, we are going to be, again, posting this online so that folks will be able to view it and review it later. You have a maximum of 20 minutes per side, although you're not required to use the entire 20 minutes. We do require that you keep track of your own time. We don't have podiums on the clock. I do have a timer that I am using, and I will occasionally jump in and let you know when you have 5, 10, give you some signposts into where you're at in your argument. If you wish to reserve any time for rebuttal, you are welcome to do so. Please make sure that you keep track of your own time so that there is actually time left at the end of your presentation to do so. We can't be responsible for that part of it. If you do have a question about your time and how much time is left, please let us know. We have read all the briefing. We have conferenced this case before we came here today. We have studied the record, so we are very familiar with it at this point. So with that, Counsel, I'm going to allow you to proceed.
Good morning, Your Honor, Counsel. I'm getting feedback on my end right now. I don't know if you are.
I am not right now. I don't know if anyone else is. I apologize if you're getting some.
All right. We'll see if I can do this. I'm hearing myself in the background. Good morning, Your Honors and Counsel. As the court knows, this is actually a relatively simple case. The underlying substantive issue is whether or not the defendants, appellees, had the legal authority to forfeit my client's vehicle. The issue essentially boils down to whether what the interpretation of 132301 D4 is. And it's our position that really Corbin v. Pickrell, which was cited in our brief, 667 P. 2nd, 1304, controls in this case. And in Corbin v. Pickrell, our Supreme Court held that a complaint for a violation of not a violation, but a civil action under 132314 for forfeiture is sufficient when, in that case, the plaintiff alleged that they had suffered damage or injury as a result of racketeering. And also when the plaintiff alleges that the act which caused the injury was performed for financial gain and was one of the illegal acts enumerated in the statute 2301 D4 and was chargeable and punishable in accordance with the requirements of the statute, to wit that it was punishable by more than 1 year in custody. So in looking at 2301, I'm sorry.
In 2002, that was changed, and it was a significant rewrite. So can we address how it works under the current statute? Because I understand what Pickrell said, and Pickrell was interpreting a statute that is not the same statute we are looking at.
Well, 2301 D4 still enumerates the illegal acts that form the basis for conduct, and so essentially it's still the same analysis, because 2301 D4 is the enumeration of the conduct which forms the basis for a racketeering statute.
Well, but it was significantly changed. The for financial gain was moved to the subsection as opposed to a lead-in. And some of the crimes listed there are in fact misdemeanors. Usury is only a misdemeanor. So how do we read it the way you're asking us to when some of the crimes the legislature purposely included are, in fact, would not be covered?
Well, Your Honor, I disagree. 2301D4 doesn't technically list crimes per se. It lists conduct, which could be considered a crime, and it depends upon where that conduct occurs, whether or not it's going to be considered a crime. The definition, I mean, racketeering under 2301D4 is merely a definition of conduct. It does not actually define specific criminal conduct. It defines conduct that forms the basis for racketeering. In other words, unlike a statute, unlike, for example, 2312, which actually defines a crime, 2301D4 is in the definitional section for the chapter, for chapter 23.
Okay, so if I take that, I have to have some sort of act, for example, and I'm going to use usury because it is purely a misdemeanor. Somebody has committed usury, but they've also committed some other crime that involves a penalty of a year or more than a year. Then doesn't that fit within racketeering? Because under your reading, as I understand it, it would not.
Well, usury may be a misdemeanor under the statutes in Arizona, but is not necessarily a misdemeanor under statutes in New Mexico or China or any other state. So the question is whether or not the conduct is racketeering, and the conduct specifically has to fall within the enumerated list of conduct within the statute. So the fact that
how does that tie to the 1 year? Because it seems to me when we read it and diagram the sentence, remember back when we had to do that and do the lines and the little things, that the first two aspects under the statute stand alone, and then the third is whether or not there's an act that involves usury independent of that.
I don't think that Corbin v. Pickrell says that.
But they've reached in the statute since Pickrell. So we need to deal with today's language.
But the basis for the analysis in Pickrell is the same. It has to be an enumerated act, and it has to be an act that can be punishable by more than 1 year in jail or imprisonment. And so it's the same analysis, even though the statute may have changed somewhat, it's still the same analysis. It must be one of the enumerated acts, and it must be one that can be prosecuted or can be punished by more than 1 year in jail. So I don't see that there's any significant difference in terms of the analysis. And maybe I'm missing your point, Your Honor, but I don't see that there's a difference in the analysis. It's still a question of whether or not this is enumerated and whether or not it's punishable by more than 1 year in jail. The only enumerated act in this case was theft, and the theft in this case was for less than $500, which automatically makes it not punishable by more than 1 year in jail. Now, so
let me put a finer edge on my question. The language before Pickrell said racketeering is any act, whether it's preparatory or committed, that first is committed for financial gain. First thing that it says, which is chargeable or indictable, either under Arizona law or another state, and which is punishable by imprisonment of more than 1 year. That's the statute that Pickrell had. In 2002, it was rewritten. It's now any act including the preparatory or completed offense, one that's chargeable or indictable under any other law, that is punishable by more than 1 year. And it is then goes into the enumerated act. So financial gain no longer precedes, it follows. And so it's not a financial gain crime now. And then it gives what those acts need to involve. So the language is very different. When you diagram the sentence, you get to a very different result with that change. And so I'm trying to understand how I read the new language. Pickrell doesn't describe the way the language works now, from my perspective, and I need you to tell me how it does.
Your Honor, it still has to be for financial gain.
Or it could be a terrorism crime.
Well, it could be terrorism as well. We didn't probably have as much terrorism going on when it was first written, but terrorism.
This was written in 2002 when that was actually a focus. And so how do I deal with the fact that financial gain no longer modifies everything by preceding the list? It is now in its own subsection and is not tied to that list.
The only difference is terrorism. And this case doesn't apply. I mean, terrorism doesn't apply to this case. Financial gain still applies to all of the other enumerated acts. So the addition of terrorism, the movement of financial gain to subsection B simply modifies or it is the same as it was before. The only addition is subsection A, which has to do with terrorism. So it makes sense to move financial gain from the beginning section of the definition to subsection B, because when it comes to terrorism, it doesn't have to be for financial gain. Terrorism by is separate.
But the crime charged here was a burglary that involved a theft. Right? And the burglary is punishable by more than a year.
That is correct.
And then when we get to the financial gain part, which follows, no longer proceeds, so it isn't modified by that. Theft is one of those ones that's included.
Well, I mean, I understand that's the argument. I don't believe that is the logical reading of the statute. Because again, burglary is not enumerated. There are how many enumerated offenses?
There are quite a few.
Yes, there's a lot. And if you look at those offenses, you'll note that there are only a couple of them that actually refer to a statutory definition of a crime. The rest of them do not refer to Arizona statute. They refer to conduct. Could be homicide, could be robbery, but it doesn't define homicide or robbery. It doesn't define kidnapping or forgery.
Well, if I'm not referring to the statute in a crime, then I never would have a case that constitutes racketeering, because none of those would be punishable by a year or more.
Well, it could be defined differently. As the court knows, we're dealing with a statute under racketeering. We're dealing with a definition of racketeering that crosses state lines. There could be, in fact, there's very likely a lot of this has to do with, for example, drug smuggling. Well, if you smuggle drugs out of Mexico or somewhere else, maybe China, I don't know, and you bring them into the United States, the conduct may or may not be considered a quote unquote felony in another country or another state. But if it's punishable in that other country or state by imprisonment of more than 1 year, and is punished, and if that same conduct were punishable in this state for more than 1 year, then the conduct would fall under racketeering. So
Arizona is only worried about usury in other places if the other places punish it by more than a year, but would not really care about it in Arizona, because in Arizona, it cannot be punishable by more than a year.
Well, usury in and of itself can't be punishable in Arizona for more than a year, but usury might be part of another statute in Arizona that is a felony offense.
For example, burglary based on a theft?
No, usury.
Why would burglary based on a theft not fit that category?
Well, burglary itself is not, again, it's not, does not have to be based upon a theft. And whether or not the facts constitute burglary, and whether or not the facts is insufficient for burglary to fall within this enumerated list. So theft is the only enumerated conduct that falls within this list, and the theft in this case is a misdemeanor.
Just so you know, you have about 7 minutes left.
Okay. Your Honor, I didn't want to spend a whole lot of time on the other issues that were argued by the defendants in their essentially a cross appeal, although it's not technically a cross appeal. But I do want to point out, Your Honor, that as I stated in the reply brief, that the estoppel argument was found in favor of a plaintiff, and the trial court found that the plaintiff is not estopped from raising this claim because he was not a party and because the issue was not actually litigated. I think this court could affirm that determination. And the other issue on Monell, I think it is premature for this court to consider the Monell issues. The trial court didn't decide the Monell issues whatsoever, and those issues ought to be sent back to the trial court. So I think really the issue in this case boils down to the simple question of did the county and city have the legal authority to take property under the racketeering statute? Does it fit within the definition of racketeering statute or not? I think the Corbin v. Pickrell still is conclusive and still applies. And I don't think that the modification of the statute by the movement of financial gain from the beginning of the statute to subsection B has anything to do with whether or not this case involves a conduct which is racketeering under the statute. Thank you, Your Honor.
Thank you. And you have 4 minutes and 55 seconds left for rebuttal, so that you are aware. Give me a moment to reset the clock, counsel. All right, go ahead.
Good morning. My name is John Barnes. I'm here for the city of Yuma and Chief Leggett. I'm going to share my time this morning with the county, so I plan to keep my comments short. But Judge Gass, I'd like to try to answer your original question. The only way counsel gets to her interpretation of the racketeering statute is by ignoring the key phrase "and the act involves." This phrase shows that the legislature distinguished between two things. Number one, the racketeering act that's punishable by more than a year in prison, and number two, the 30 plus enumerated offenses. So adopting counsel's construction would render this key phrase and the distinction it implies meaningless, thereby fundamentally changing the meaning of the statute. And this court has already recognized that distinction in the Nissan Sentra case, where the court affirmed forfeiture based on charges of promoting prison contraband. Because promoting prison contraband is not one of the enumerated offenses, the court expressly recognized that the act of racketeering that's punishable by more than a year in prison need not be one of the enumerated offenses.
Well, let me ask you this, because Nissan Sentra was before the 2002 changes, correct?
Right.
And so it wasn't dealing with the statute we have now, but it seems to have somehow reached the same conclusion that I was talking about with the rewrite. Would you agree?
Yes, Your Honor. I think that even the cases that predate the rewrite, though, recognize the distinction between the act of racketeering and the enumerated offenses. And so long as—
So you believe we would reach the same result under the old language?
Yes.
And then let me ask you this, that what Nissan Sentra said wasn't central to its holding, was it?
I think it was, Your Honor. The court's, it's paragraph 9 contains the key language in the decision affirming the forfeiture. And then paragraph 10 and thereafter is where the court goes on to address the counter arguments. And so I do think paragraph 9 is essential to the holding in Nissan Sentra. And just one more point on Nissan Sentra. I think if the court had not recognized that distinction between the Racketeering Act and the enumerated offenses, the court would have simply stated that the offense involved marijuana and left it at that. But instead, the court went a step further, and just to read the key sentence, although Simmons pled guilty to facilitation of promotion of prison contraband, a Class 6 felony, the state had ample evidence to support the indictment against Simmons for promoting prison contraband. And I think that's the key sentence, because it shows that the court was focused on not one of the enumerated offenses under the racketeering statute, but on the act that's punishable by more than a year in prison. And so by analogy here, we're looking at burglary, which is the act that's punishable by more than a year in prison. And it involved theft, exactly the way the statute reads. So whether we're looking at the plain language of the statute or the cases interpreting it, plaintiff's interpretation doesn't hold up under scrutiny. Are there any questions for me on this issue? Are there any questions for me on any of the other issues raised in the briefing?
Well, let me ask you this. If we agree with your position on the interpretation, do we need to reach the other issues that are raised?
No, Your Honor, those are secondary.
There are other cases since this statute has been changed that have looked at the Pickrell language and parroted that. What do we do with those?
Well, let me just look at, I think there's a key passage from the Pickrell case that will clarify things. And I'm quoting, "We hold, therefore, that a complaint is sufficient to state a cause of action under the racketeering statute when it alleges that a plaintiff has suffered damage or injury as a result of racketeering, and further alleges that the act which caused the injury was performed for financial gain, was one of the illegal acts enumerated in the statute, and was chargeable and punishable in accordance with the requirements of the statute." And I think that's the key paragraph, because the court, in other words, is distinguishing between an act of racketeering, and that's the injury as a result of racketeering language, and on the other hand, acts enumerated under the racketeering statute. It's drawing a clear line between those two issues, just like we have discussed here this morning.
And is the line clearer because of the rewrite, or does that muddy the water on that?
Oh, I think it makes it even clearer. And I'm happy to answer any other questions. Otherwise, I will pass to the county.
And for the county's purposes, we're at 14 minutes and 16 seconds.
Thank you, Your Honor. Your Honor, my position is that this court has already addressed this issue. Again, back in Ray 1996 Nissan Sentra. That's the case that the trial court relied on to dismiss this action. I noticed that in Angulo's opening brief, page 13, they argued that the act of prison contraband wasn't one of the enumerated offenses, but that the court could have relied on marijuana as being a felony offense. They said that the enumerated felony offense of possession of marijuana was really what the court relied on. That's hard to find that from a plain reading of the Nissan Sentra case.
Well, in fact, we can't make that conclusion from the Nissan Sentra. We don't know whether it was a felony or a misdemeanor possession of marijuana from the way it's written.
Correct. It doesn't address it. The city's answering brief stated that that they relied on the prison contraband because prison contraband could have sent her to prison for over a year. And they unfortunately stated that the marijuana is a Class 6 that only allows 1 year in prison. I think that's a misstatement. More than likely, or In her case, she committed this offense after 1999 when the Supreme Court in Kalik v. Kongable decided that simple possession of marijuana could no longer send you to prison. So that was the law in 99. This case was about 2001. So it's understandable that the court was not going to rely on the fact that she was possessing marijuana, and I think it was a small quantity, to use that as the act that was racketeering. And they relied on the act of prison contraband.
But again, I come back to it, they didn't make that clear either, because if she had multiple offenses involving marijuana, then she could have been incarcerated.
And Your Honor, I didn't have the opportunity to find the briefs in that case. So I'm assuming that was the case, but you're correct. The court was completely silent. They relied on the offense of prison contraband, whether it was because they were worried about marijuana being a class 6, and one could argue that a class 6, the presumptive is 1 year, and I could see the argument back then being that we rely on the presumptive 1 year, and the statute makes it clear it has to be punishable more than 1 year. And Angelo's brief, or reply brief, made the issue that that she was possessing marijuana and that's a felony. Well, it's not that something's a felony, it's that it has to be able to imprison you for more than 1 year. So I think the Nissan Sentra is already holding that the correct reading is you decide if somebody's committed an offense that can put you in prison for more than 1 year, then was it committed for financial gain? And it doesn't have to be, the gain of the particular actor. It could be any of the actors in the racketeering. And did it involve one of the enumerated offenses? And theft in this case is an enumerated offense. In that case, it was marijuana. The other issue is, why isn't burglary listed as one of the offenses? And in many cases, burglary does not.
So you're at 9 minutes.
In many cases, burglaries are not committed in a way that would seem to be racketeering. However, when a burglary involves a theft, it fits the definition perfectly. Just as when prison contraband involved marijuana, it fit the definition perfectly. And we'd reserve the balance of our time. Does the court have any questions?
I'm not seeing any from the other judges. Give me a moment to reset the clock, counsel, and then I'll give you your rebuttal time. All right, counsel.
Thank you, Your Honor. Apparently, the city and appellant agree that the critical language in the Corbin v. Pickrell case is the same, the holding. And the holding, again, states that the allegation must contain an allegation that the act which caused the injury was performed for financial gain and was one of the illegal acts enumerated in the statute, chargeable and punishable by more than 1 year. I'm going to go to In re Nissan Sentra because that seems to be the case that both the city and county, as well as the trial court, relied on. And In re 1996 Nissan Sentra is quite different from this case. First of all, the issue that we're discussing or have raised in this case was not raised in the In re 1996 Nissan Sentra case. In that case, the issue was whether or not the conduct was committed for financial gain. That was the issue that was briefed, argued, and decided. And so the discussion regarding the promotion of prison contraband was really dicta, because it was not important to or not critical to the decision of the court whether or not the conduct was for financial gain. In that case, even though the court made the statement about the promotion of prison contraband, the underlying marijuana conduct, there was probable cause to believe that that conduct was both committed for financial gain and was, in fact, an offense that could subject the owner of the property to more than 1 year in prison, because the conduct included transportation of marijuana to the jail. It included, in essence, it could have been alleged that there was a conspiracy to commit sale of marijuana or any other numerous offenses. A Class 6 felony, for whatever reason, this court, or not these judges, but this court implied that a Class 6 felony could not be punished by more than 1 year in jail, but that's simply not true. It can be punished by more than 1 year in jail. It could then, and it can now. And so the fact that it was a Class 6 felony that the owner of the property in the Nissan Sentra case pled to is really kind of irrelevant, because the issue was whether or not the conduct itself could have been punished by more than 6 months in jail. More than 1 year in jail. So I don't think Nissan Sentra really answers the question. I don't think that Nissan Sentra, I think that the trial court in this case, deciding that there are actually 2 steps in the process, is not supported by any of the case law. And that, again, we would simply say that Corbin v. Pickrell is controlling in this case, and it's still controlling despite the what I would consider to be minor changes in the definition of racketeering that added the terrorism under subsection A. If the court has any other questions?
I do not, and I'm not seeing any. So thank you, counsel. We appreciate your arguments. We are going to take the case under advisement and issue our decision in due course. We are going to stand at recess to set up for our next oral argument. So we'll be all leaving this room, and wish you folks well. Please stay safe and healthy out there. And thank you again for the argument today.